What if your spouse won't sign any papers? Can you still get divorced in the state of Michigan? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. The short answer is yes. If your spouse refuses to sign any papers, to accept any papers, can you still get divorced? Yes, the court is not going to hold up your divorce because they're being an idiot. Of course, not going to do that. The court will allow you to proceed by default. If they don't want to weigh in on what goes on, that's up to them. But the court will continue the case going so long as you can show that you served them appropriately. There's a proof of service in the file that says such and such person was served in an appropriate manner authorized by the court rules, and therefore we're going forward with the case. And the court will let you do that. And if they don't want to sign, then they're being silly because then they don't get a chance to weigh in on the process. In other words, not signing the papers is not going to stop the divorce process. So if you're on the other end of that and you think that I'm not going to sign because I don't want to get divorced, you're in for a rude awakening because that divorce is going to happen. Michigan is a no-fault divorce state. That means the amount of proofs that have to be submitted is limited. And that goes all the way to the beginning when it has to do with whether or not you were served. All they have to do is show that you were given these papers by a means authorized by the court rules, which could mean handing it to you. It could mean tacking it on your door. It could mean publishing in the legal news. If you were served by some legitimate means, that divorce is going forward. Judges, do not let people avoid divorces by ghosting other people. That's not how it works. If somebody's a resident of the state of Michigan for the appropriate amount of time and of the county where they filed an appropriate amount of time, they have a right to come before the court and ask for a divorce. You want to participate? Fabulous. You don't want to participate? Also fabulous. They're going to get that divorce either way. And if you come back later on and say, well, Judge, it wasn't fair. I didn't get this. I didn't get that. Expect the court to say, wait a minute. This was done by default. You signed for it. Where the hell you been? Now when it's over and I've already signed these orders, you want me to set them all aside for you? Well, you may get a judge who will do that. Expect, though, to get the court to say, look, this person did whatever they had to do. This person followed all the rules. You chose to not participate in the following of any rules. I'm letting it stand. And you can appeal that all the way up to the Court of Appeals and beyond. And you know what? The court may feel sorry for you, but the court may say, look, you were served properly. You had ample time to do it. You chose not to participate. You're done. And you can expect that that might happen. So I guess every case is different. You know, there could be cases where a person really didn't know. Let's say a person was served, but they were unconscious in a coma in the hospital. I mean, there are situations where you could come back before the court, but those are few and far between. If you have questions about your case, reach out. We'll be glad to help you out.
248-588-3333. 248